I'm John Schneider. I'm chairman of the zoning board in Needham. I'm here to talk a bit about who we are, what we do, and then to talk people through the process that we use to reach decisions. So to start out, I would say that we're a quasi-judicial body, meaning that we make decisions based upon what written presentations are submitted and the testimony we have at hearings. We do not talk to applicants or their attorneys outside the hearing because we're supposed to restrict our decisions to what we hear at the hearings. We're subject to the open meeting law, which means that we cannot talk to each other outside the meeting. We have to hear testimony, reach our decisions, and announce it all at a public hearing. We are not the legislative body in connection with zoning. The zoning bylaws are proposed by the planning board, adopted by the town meeting, and so we are just a body that's applying the zoning laws within the scope of what we do. Every town has a zoning board. It's established under state statute, Chapter 40A, which governs zoning. We're appointed by the selectmen for a term of 3 years, but it's been pretty much the practice in Needham to let people continue with reappointments so we have continuity. I've been on the zoning board for over 25 years, and my vice chairman, John Tampkin, has been on the zoning board for over 15 years. We're technically a 3-person board, but there are also 2 alternates. It's sometimes confusing to people that all 5 of us are at hearings, but I think it's a good thing that the alternates participate so they know what's going on. They learn the process and how we're deciding. They ask questions, participate in the discussion, but when it comes time to vote, there are only 3 voting members of the board, and those are usually the regular board members unless I designate one of the associate members to vote in connection with a particular hearing. Our decisions have to be unanimous, and interestingly, we almost always reach a unanimous decision. In all of my time on the board, there have been very few split decisions. That's only when someone has a very strong feeling against or for something that's contrary to the other board members. If they feel it's kind of close, we go along so we can reach unanimous decisions. Chapter 40A, the Massachusetts statute, assigns a number of duties to us. The first is that we handle appeals from decisions of the building inspector. If someone is denied a building permit, they can appeal to us. If the building inspector issues a building permit that the neighbors object to, they can object and come to us for a review and decision. After us, people are off to court, land court or superior court, to review our decisions. The second thing that the statute assigns to us is to hear variances. Now, some people think that means anything that's a change in the zoning bylaw or a waiver of the zoning bylaw, but in the early 80s, Massachusetts changed its statutes to make it very difficult to obtain a variance. It has to be because there's an unusual condition of the shape, topography of the lot, and it has to result in a hardship, and a hardship doesn't mean that you have a 3-family house and you can't put on a 4th bedroom. It pretty much means that you couldn't use the property without a waiver of the zoning bylaw. So we hear very few variances in Needham. The third statutory duty that's given to us is to make decisions under Chapter 40B, which is the affordable housing law. We spent a whole lot of time a few years ago dealing with the project on Greendale and 2 big projects down in the industrial park. Those are very difficult because it's multifamily housing going into a single-family neighborhood. People are understandably quite upset. We're asked to do a full planning process, which is not what we usually do, because most new projects go before the planning board, who has paid staff. So we have to rely upon other town people to reach these decisions. I don't think we're going to see many more of these because the town has now reached its state mandated goal of 10% of the housing stock in Needham is affordable. So I think no more 40Bs. Now, the other big thing we do are duties that are assigned to us by the zoning bylaw. For many matters, we're the special permit granting authority. It wouldn't have to be the ZBA. In some towns, it's different bodies, but our zoning bylaw gives us many areas where we have to deal with special permits. The first kind of them are some uses require a special permit. Examples of that are restaurants, dry cleaning establishments, veterinarian offices that are in commercial districts. They're not allowed of right because I think they're viewed as somewhat difficult kind of uses, so they have to come before us for a special permit. A second type of special permit is a modification of the use of a non-conforming property. We, for instance, have before us right now a property that involves a greenhouse and a contractor's yard and a two-family house, and they want to change that use to two-family houses, and that's allowable only if we issue a special permit. A third kind of special permit would be for an expansion or a change of a non-conforming use. A property becomes non-conforming when there's a change in the zoning bylaw and it was legal, and it now becomes out of sync with the new bylaw. A lot of Needham properties are in that condition. So we hold hearings to deal with things like putting a second story on a house that's non-conforming, to rebuild a house that's non-conforming, or the ones that are really contentious are to rebuild two-family houses. There's been a raft of developers trying to find old houses that are two families in single-family neighborhoods and coming before us looking to rebuild those. If they rebuild them at the same size, they can do it right, but they naturally and typically want to expand them substantially, and they have to come before us for a special permit. Some other examples of special permits are that in the zoning B district, which are the smaller lots of 10,000 square feet, people are allowed 2 garages of right, and if they want a third one, they have to come before us for a special permit. And in the larger zoning area, Residence A, people are allowed 3 garages of right, and then they can come before us for a 4th garage. Some other examples of special permits are that the town has adopted a limitation on retaining walls. People are allowed to have a 4-foot wall within the setback, but if they want to have a higher wall, then they have to come for a special permit. That was a new provision adopted a little over a year ago, and we've had a couple of hearings this year on larger retaining walls. Another example, which has not been coming before us recently, but cell towers and communication towers are not allowed in place without a special permit, and there was a time when they were building out the systems when that was a regular occurrence, that they were before us for special permits. So now I'd like to talk about the process for someone who is looking to obtain a special permit, or for that matter, any other relief that would be required by the zoning board. The first step should always be to visit the building inspector. Some people have the impression that we can decide what they build, and that's just not true. Ultimately, in order to build something, they must get a building permit, and they should see the building inspector to find out what he thinks is required from the zoning board in order to move forward. The next step is to file an application. The applications are available online or in the zoning office. And the one complication is that people need to have a certified plot plan that accurately describes the property that's prepared by an engineer. It shows the size of the lot, the distance from the lot lines, and certifies the zoning district where the property is located. The cost is $200 for a residential property, $500 for a commercial property, plus the cost of advertising. Before we hold hearings, they have to be advertised by public notice in the newspaper, and that means that the deadline is about 3 weeks or a little over that before the time of our hearing, because we have to have notices. Our hearings are typically the third Thursday of every month. There is a published schedule at the website or available in the zoning office that give those deadlines when applications must be filed. So after the application comes in, the notice is given in the newspaper, we hold a public hearing, typically here at the Charles River Room, the Public Services Building on Needham Avenue, but occasionally when there are conflicts at other locations. Many times those hearings are complicated, there's something missing, there's a lot of opposition by neighbors, and we'll continue those hearings to another date. We do post a notice in Town Hall, and it's available at the zoning office, what's on the agenda. When we've gone as far as we can go of getting people to agree and feel we have a complete record, we deliberate and decide at the public hearing. We announce our decision, but then we have to put it into writing, and that typically takes 3 or 4 weeks. It has to be signed by all the members of the zoning board, filed with the town clerk. There's a 20-day waiting period after the decision is filed. Once that has expired, people can pick up the certification from the town clerk and record it at the Registry of Deeds. And then they're ready to go get their building permit from the building inspector. This process, because of the time period leading up to meetings, the writing, and the 20-day wait period, is at best 60 days and more typically 90 or 120 days from beginning to end. Our philosophy is that we're not looking to block what businesses or residents of the town want to do. If people want to do something reasonable, we try to find a way under the zoning bylaw to let them do it. I guess the second thing that's important to our philosophy is we really listen to what the neighbors have to say. And when people object, within reason, we try to get the developer or the applicant to respond to those concerns and to come to an agreement. Finally, I mentioned we do have a website. Their rules, our schedules, our agendas are all available. And if people have questions, Daphne Collins is our administrative clerk. She's in the zoning office in the Public Works Building. Her number is 781-455-7550, and she'll talk to people on the phone or in person and try to give you guidance to walk you through this process.